Hi, I'm Mike Brown. I'm an attorney with Elder Law of Kansas here in Derby. And the purpose of this DVD is to explain to you some of the issues you need to consider as far as estate planning is concerned. Now, when someone calls me about an estate plan, that could be a lot of things. It could be a will, quitclaim deed, power of attorney, a trust, what have you. But the important thing is when someone walks in the door to do an estate plan, they don't walk out the door with an estate plan that's going to cause a probate. And there's a lot of ways to protect your assets and avoid probate. Now, only 35% of Americans have wills. What they don't realize is the other 65%, they have a will too, is that the state of Kansas has written it for them, and believe me, they're not going to like it. With a will, you can incorporate by reference a trust. And we do a lot of trusts for people. But I want to emphasize, as far as a trust is concerned, dollars and cents is not the sole criteria. It also depends upon the objective of the clients as to how they want their property distributed. Yes, a trust is great. It avoids probate. It maintains privacy. You can put a few more strings attached on the distribution of your property. But you still need a will to work in conjunction with the trust. On the other hand, if you have items of intrinsic value as far as personal items, dishes, jewelry, what have you, you can also have incorporated by reference in your will what's called a personal property memorandum. So you can distribute these items to children, grandchildren, and not have to come back to the attorney and change your will. So you have a will, and when you come in, you're here. This is our estate. And we're going to utilize either a will or a trust to distribute that property when we pass away. Well, that's the easy part. Not to make light of it, but in 5 seconds of dictation, I can get a client from life to death. The problem is, what if you decide you're going to live on me? Well, that's the hard part. You got to prepare for life. The good news is we're all living longer. The bad news is we're all living longer, sort of torn between two crosses, if you will. Yes, you can use trust to avoid probate. If you don't need a trust, you can utilize transfer and death deeds, payable and death account designations. There's all types of tools available for you. But if you think you want to keep on living, here's some of the issues you need to consider. First of all, you need to contemplate having a living will, which is sometimes referred to as a death with dignity document. If you've been diagnosed to be terminally ill, incurable disease, perhaps you're brain dead, you would be requesting comfort care rather than to be kept alive by artificial means. To be blunt, you've made the decision to pull the plug, and you've taken that decision away from others, so there's not an argument going on but amongst family members, and you're in the hospital and the doctors are asking, well, what are we going to do, folks? The next thing you need to have in place is what we call a HIPAA authorization letter. Since 1996, we've been dealing with the Health Information Patient Accountability Act. And that's a document that authorizes healthcare providers to release information about your health care, perhaps to members of your family, business associates, what have you. It's whomever you designate. On a personal matter, I dealt with this a couple weeks ago. We thought my brother-in-law was going to go down for the count. My sister-in-law called out to the hospital. They wouldn't do a darn thing because her name was not on the HIPAA authorization. The next two documents you need to consider are durable powers of attorney, one for healthcare decisions, the other for financial. I think of them as an ounce of prevention is worth a pound of cure. You need to have somebody appointed as an agent that, heaven forbid, you become disabled, someone's there to belly up to the bar and make healthcare decisions on your behalf, be able to handle your financial affairs. And I want to emphasize, a nursing home or a hospital is not the place to start this planning nor fill in the blank powers of attorney. With respect to your health care, your agent needs to have dealing with obviously healthcare decisions, but hospice long-term if those issues arise, the ability to obtain and release medical information. Also have the authority as far as if you're in the hospital and you're asked what code to be placed on the chart, they can put a do not resuscitate code on that chart pursuant to your instructions in the living will. Next, you need to take those 3 documents and put together a vow of life, which we do for our clients. In that vow of life, you take those documents, we work with EMS, and you put them at home on your refrigerator. So heaven forbid, if EMS is called out, they see the decal on the front door, they go to the kitchen, they have the documentation, and they start making phone calls right from the kitchen to avoid the situation where a spouse may be out of town and finally, 9 o'clock one night, the neighbor finally hunts her down and says, hey, they took your husband to the hospital today. The next power of attorney that you need is the financial power of attorney. And that needs to be extremely thorough to try to anticipate whatever could happen to you. Once you have these documents in place, you're in a position to avoid having to go to court to do a guardian conservatorship. You don't have to go to court if you have the properly drafted documents in place. Then there are some collateral issues which you need to consider, such as burial instructions, whether you want to be cremated or be buried. You can also deal with child care plans. We have clients that have young children, and I contend a person's more than a name, date of birth, and a social security number. So we put together child care plans on each child so the guardians know about individual children that they may be placed in a position to have to raise. But you ought to do the same thing for yourself, a personal care plan. As to if you became disabled, how would you like to be cared for? What do you think your healthcare provider needs to know about you, especially if you're in long-term care? Another document you need to have in place is an inventory. It doesn't have to be extensive. Just where is all this stuff? Yeah, we know where mom and dad lived, but where are the investment accounts? Where are the banking accounts? Where's the insurance policies, the annuity policies? And those are most important to know who the agents are, the policy numbers, the insurance companies. Sometimes I have people come in and they give everything to me in a big cardboard box and tell me, there it is. And so the hunt begins. There's other documentation you need to deal with besides the burial instructions, also instructions to your agents as to how they should handle your affairs. We provide those to our clients. Now, I could go on, and I don't want to inundate you with too much information, but if you're interested in coming in and visiting with us, we don't charge for initial consultation. You can give us a call at 316-777-1186. In addition to estate planning, we also handle probate matters, and we also deal with Medicaid, which is another story that I will not be able to go into at this point in time. Again, thank you very much for contacting us. I hope this DVD was helpful. Look forward to visiting with you. Again, thank you.